Hey everybody, it's Joel Williams, and welcoming back Chase Elleby after his relief and absence from a couple videos lately. But today we want to talk to you about the top 10 tips for negotiating with an insurance company. So we'll just jump right into it. Chase, what's your first tip for negotiating with an insurer?
First, I want to say it's great to be back, so thank you for that intro. I would say number one is be prepared and have your evidence.
That's subjective or objective?
It's both.
Oh, okay. Nobody asked me.
Number one, be prepared, right? Have your evidence lined up. That's open records request. You can get videos, you can get the incident report, have photos. Let's say it's a car wreck case, obviously is the most, I think, common thing you're dealing with an adjuster on. Have the police report and just kind of have your ducks in a row with the evidence so you can make it as easy as possible. And that includes medical bills, medical records, all that type of stuff. Because I always say to my clients that insurance companies are in the business of accepting premiums and denying claims. So you need to make their job as easy as possible, give them all the information and evidence that they need to adjust the claim in your favor.
Yeah, and having those documents and things that you can send to them to substantiate the claims that you're making is going to make it a lot easier because, even though your claim is legit, they have probably 5 other claims that are complete garbage.
Right.
So they don't just take your word for it. You got to be able to back up with what you're saying with evidence.
Right, exactly.
And so that goes to proving that it wasn't your fault, proving whose fault it was, proving that incident caused your damages, and then what the damages are. So photos prove what happened. The medical records prove the injuries that you have. The medical bills prove your damages, any pay stubs, all that kind of stuff. Just have it all together before you begin negotiating with the insurance company. But turning off of just the facts and having all your evidence together. So not only is it important to be prepared with the evidence and the documents that you need to back up your claim, you also have to be prepared on the law. If you're not going to hire an attorney, you need to be able to spend time figuring out what the law is in the jurisdiction that you live in or the state that you live in, right? So there's different traffic laws. There's mostly uniform, but they do differ from state to state. There's different regulations that apply to industry. There's different laws regarding what exactly you can recover, for lost wages, for example. Like, can you recover for future lost earnings, and what do you need to prove that under the law of your state? So the adjuster is likely going to know the law of your state. So it behooves you to be prepared and know the law, at least as it applies to your particular claim.
Yeah, and I think so. Number 3 kind of segues into knowing the law is when you get to the point that you're ready to sort of make a claim or speak with the insurance company, always do a written demand, right? Always have it written down and know the specific requirements of the state that you're in for what sets up a good demand, right? Because most states have certain laws and certain things that you have to say in a demand to potentially set up the insurance company for bad faith. I know we've done a video on bad faith at some point, but essentially you have to give the insurance company a reasonable amount of time to pay a claim, and if they don't, you can prove they acted in bad faith, then there's a potential to recover in excess of the policy limits that may have covered that wreck. But in order to do that, you're going to have to know the law, you're going to have to know the specifics that go into each demand in order to give the insurance company the opportunity to settle.
Yeah, and in some states there's ways that you can write a demand for what we call an unliquidated damages demand. In other words, you send it, and if the insurance company doesn't pay it and you later have to go to trial and you get more than that, then you may be entitled to prejudgment interest, which right now, at the time we're filming this video, in Georgia is 10.25% because it's prime plus 3%. So if that drags out over 3 years and it's a lot of underlying, the damages that are awarded are large, then that interest can add up pretty fast. So going back to that, when you go to negotiate with an insurance adjuster, if possible, and this is number 4, it's important to know the limits of the policy that you're dealing with. Because if you go to an insurance adjuster and say, I want $1 million, but the adjuster's only got $100,000 on the policy, they couldn't pay you the $1 million if they wanted to.
Right.
Because they're insured, or the person that hurt you only purchased $100,000 of coverage. So you kind of have to know the parameters that you're dealing with when it comes to numbers, so that you're negotiating within the appropriate range.
Right, and like Georgia, for instance, we can find out what the policy limits are before sending a demand. Other states like Tennessee, obviously, they don't tell you, but if you demand high enough, the adjuster might call you and say, hey, by the way, I appreciate the demand, but we only have X amount in coverage,
Yeah.
so there's ways to find out.
Have that
right, we don't
much.
quite have that much, but you're getting close. So the next thing, I'd say number 5 would be to time your demand or your negotiations right, okay? And there's a couple things to consider. Number 1, if you are fortunate to be able to know what the limits are, and you say the damages are super high, and you know the limits are pretty low, you can time it by sending a demand pretty quickly because you know what you're working with. If the limits are really high and your damages are sort of in the unknown category, meaning you're still treating, there's no point in negotiating or sending a demand to the insurance company and settling your case only to find out, 3 months later that you still need to treat or you're still in pain. And another thing to consider is also the statute of limitations, right? So you don't want to wait around, send a demand, statute of limitations, comes and goes. You don't hear anything from the insurance company. Now you can't file the lawsuit. So another thing to consider as well.
Yeah, and I like to do this once we're in litigation. In other words, after the lawsuit's been filed too. I like to send demands when things are going my way.
Right.
Like when I've got the upper hand, the other side may be a little nervous, then hit them with the demand. Like for example, if we take the deposition or out of court sworn testimony of the person who caused the wreck and it goes really bad for them and really good for us, maybe that's a good time to send a demand.
Right.
Or if you take the deposition of a doctor and the doctor comes in and says, yeah, this wreck caused these injuries, that may be a good time to send a demand if the area that's being disputed is whether the wreck caused the injuries, right? Let's see, 6, we're on 6, right? All right, so number 6, I would say it's easier for us as lawyers to say this than it would be if we were in the injured party's shoes. But negotiate based upon facts and law and try to detach yourself from emotion. So you always want to be negotiating using reason. So it's rarely a good idea and it's rarely effective if I call the insurance company and go, if you don't pay me this, I'm going to sue the crap out of you, right?
Right.
They hear that 1,000 times a day.
They're like, sue me. It goes off my desk and goes to another adjuster.
Yeah, it goes to somebody else, right?
Right.
So that rarely works. But in the negotiation process, if you say you demand $100,000 and the adjuster comes back and says, well, we're only going to offer you 50, and you may need to go back to them. My first question is, well, why? Like, what's your reason for only offering that amount of money? And if they say, well, that's all the authority I have, but they can't give me any facts or something to support that, then I don't really have anything to consider. So why would I move off of my 100, right? However, if they say, well, they give me some facts and they give me something to think about, then maybe I go to them and say, okay, well, I understand that, so maybe we'll go to 95, but if I want them to come off of their number, I need to give them some facts or a good reason to do that, right? So we're negotiating based on evidence and law and not just raw emotion. And I understand that's difficult sometimes because there is emotion involved in it, but you're probably going to get a lot further if you want the opposing side to do something if you give them a good reason to do it.
All right, and I always have this conversation with clients too, because one of the items of damages in Georgia you can seek are the intangible damages, the pain and suffering damages, right? Which is whatever the enlightened conscience of a jury decides it's going to be. And most of the time, in most cases, you already know who's at fault. You already know sort of what the hard damages are, the medical bills, but you're usually arguing over that gray area, the intangible damages. And of course, us as the plaintiff's attorney representing our clients, we always, that's a big number for us, right? Because we hear it from our clients feel it, they experience, they've lived that harm. Adjusters, and if we're talking just your sort of run-of-the-mill, big insurance company adjuster that has thousands of files, couldn't care less. They don't. It doesn't go in their evaluation, and when and if it does, it's based on some formula that's usually tied to some objective measure, like the amount of medical bills or the CPT codes on the bills, and then they spit out a number. So they have very little leeway, and it's sometimes that can be tough in explaining to the clients, like, we have to negotiate with evidence and give them things, but the adjusters are not emotional. They're not tied to. They're not going to feel sorry for our client. They can't. They're trained not to, right? Because if they did, I would like to think that most people would be like, okay, I'm going to give you more money, but it doesn't work that way. So those intangible damages are always hard to get adjusters to come up if there's not like really good evidence by, say photos or something like that to show the extent of the wreck or the extent of the injuries that kind of add juice to it.
Yeah, there's only certain things that will move the needle for an insurance company pre-suit.
Yeah.
And heck, sometimes we can go to trial and get a whopper of a verdict that gives true value for those intangible damages, and then the insurance company still doesn't want to pay.
Right.
Or they'll come back and say, oh, well, I know you got a verdict for $1 million, and we only offered you $100,000. Well, we'll offer you $500,000 now.
Yeah.
I'm like, no.
Right. It doesn't work
Here's
that
the
way.
judgment that says you have to pay this, right?
Right.
All right, so number 7.
Yeah, we're on 7. Well, it kind of ties in with like sort of been negotiating, try to negotiate from evidence. One of the factors that you consider when negotiating is going to be the jurisdiction of where your case is. So you kind of want to have a good idea of like, in Georgia we've got 156 counties, I believe. You want to know where, if we were to file a lawsuit, which county that's going to be in, and sort of generally, how does that county, what are the results of that county for similar type cases, so you can kind of gauge what the value of your case might be. Now, it's not an exact science. Every single case is different, but you can sort of get a sense of, okay, this is a more conservative county. They don't like pain and suffering damages, or this is more of a, not even liberal is not even the right word, but this is more of a progressive county, say, and they'll give more for pain and suffering. Because we hear that a ton. Oh, well, this case is filed in X, so that's why we offered Y. It's like, okay, I get it, but you haven't, really considered ABC, so I think you're just sort of blanket analysis of this being a bad county and offering a bad sum, it's not justifiable, but,
Yeah, and this is one area where having a lawyer, an experienced lawyer on your side can really come in handy, because they're likely going to know or have access to resources where they can pull data and pull past results from that county, where you can actually go to the adjuster and say, hey, look, here's 10 different cases virtually identical to mine where they awarded X amount of dollars. That's why we think this is fair. And that's just one of those examples of giving the other side a good reason
educating them
to adjust their evaluation of the case, right? All right, number 8. This is very important, super important. Don't make false threats. Like, if you threaten to do something, if you say, if you don't do A, then I'm going to do B.
You better be ready to do B.
If they don't do A, you better be willing to do it. Because the second that you don't follow through with the action that you say you're going to take, all credibility is lost.
Right.
If you say, I'm going to sue you if you don't pay me $25,000, and then you come back begging, well, I'll take 20. Like, that's, you just shot yourself in the foot. So it's okay to make ultimatums when the time is right to say, hey, look, if you can't get to this number, then I've got no choice. I'm going to have to file a lawsuit, or I'm going to have to hire a lawyer, and we'll go from there, right? It's okay to do it as long as you're willing to follow through with it,
right?
Yep. So what's number 9?
Number 9 is don't settle too soon. I kind of touched on a little bit about timing and when to send the demand. But you don't want to sell yourself short and settle your case too soon if you know you're going to continue to treat, or there might be more damages later on down the road, or you haven't gotten all your lost wages calculated, or whatever it might be. Just know that, well, you want to know obviously what jurisdiction you're going to be in, so know your statute of limitations, so you know how much time you have. But you just don't want to do it too soon and say, oh, I want to be done with it, just to kind of wrap the case up.
Yeah, so, know the full extent of your damages.
Right, exactly.
And have the stuff to back them up.
Yeah, exactly.
I'd say last but certainly not least is consider hiring an attorney if you get a garbage offer up front. Right. So I'll give you an example. Progressive is pretty bad about this, calling you up and saying, hey, we're going to give you $2,000 without knowing anything about your damages. Right. If that happens, that tells you they're not really concerned about your case. They're just trying to get out of it cheap early on. If something like that happens, it's probably in your best interest to hurry up and hire an attorney to deal with it for you. Yeah. But we get it. Like, there's cases where you're worried, or we worry about whether it makes sense economically to hire an attorney, whether it's going to be worth my time or worth their time, and am I wasting time? I would say most good attorneys are gonna add value to the case no matter what. But there may be situations, but those same good attorneys, if they don't think they can add value to the
They'll
case,
tell you, right?
will tell you, hey, you can probably handle this on your own.
Yeah, and I would say sort of to add to that is just consult with a lawyer too. Just because you consult with one doesn't mean you necessarily need to hire one, because there's been plenty of times I've talked to folks and they've kind of given me the rundown. They've been dealing with the insurance company's offered them why, and I just kind of lay it out for them, like, this is what you're looking at. It's up to you. You may or may not need me. I'll let you make that decision. And a lot of times, I even will say, hey, try this, and if it doesn't work, then come back and we can talk about it. That happens as well. So I would say at least consult, especially if you're getting to the point where you're about to put pen to paper and finalize something, because you're going to want to know your rights. And I'd say a good example with that, like here in Georgia, is we have what's called the collateral source rule, which means, you might have $10,000 worth of ER bills, and your health insurance might pay for most all of it, and you might be out of pocket $1,000. Well, most folks don't know that you're entitled to that entire $10,000, even though you had health insurance.
Yeah. But the first thing the insurance company is going to do is
it's
say,
not telling that. Yeah.
how much you have to pay out of pocket.
Right,
You're
exactly.
going to be like $1,000, and they'll say, oh, we'll give you $1,000 plus $1,000.
Right, so they think they're getting, a good deal, which, if that happened most of the time, then most of our clients probably wouldn't call me because they think that that's probably a fair deal. Mm-hmm. But a lot of times it's the insurance company offering even less than what their out-of-pocket expenses were. But I just give that, that quick story to highlight, before you sign anything, just kind of get a rundown of what your rights actually are and make sure you're not leaving anything out there.
Yep. So. All right, well, that's the top 10. Chase, if you had to pick one that's the most important thing to think about when you're dealing with an insurance company, what would it be?
Jeez, talk to a lawyer.
Talk to a lawyer.
Right.
I would say mine is be prepared, and it's kind of two. Be prepared and be honest.
Yep.
You need credibility, and you need the evidence to back up. If you're asking somebody to do something, you got to be able to prove to them why they should do it.
Yep.
So be prepared, be honest, and consider talking to a lawyer. If this video has been helpful to you, we sure would appreciate a thumbs up. Insert any comments you have into the section below, in the comment section below. If you have any other ideas that you have found useful when negotiating with certain insurance companies, we'd love to hear those. We love to learn. We love to learn from other people. So if you have any good inside tips, go ahead and throw those in the comment section below. If there's any insurance adjusters watching this, I'd love to hear from you. Like, what tactics have attorneys used that you found effective before? So we appreciate you spending time with us today and going over all of these different tips for negotiating with insurance companies. But we will see you next week, same time, same place, for our next video.